Welcome, everybody. This is NWSOFA, which stands for Northwest Suburbs Organizing for Action. We're an organization in the land beyond O'Hare. That's the Northwest Suburbs of Chicago. We cover basically 6 townships, and we're organized with about 5,200 members, and we have 24 leads that present these meetings on a routine basis. Our goal is to help you understand the facts, to help you sharpen your arguments, and to help you communicate with your friends and your audience, your personal audience. We're organized on a snowflake principle. You probably have heard about snowflakes. And that basically means that we're a very shallow organization. We don't have a lot of layers. As you on the right-hand side in the teal, you can see our different issue groups. Starting with our very first one up on the top left was the gun violence prevention. Then we added healthcare reform. Then we added immigration reform. That was called originally comprehensive immigration reform. Then social justice, stand with women, which is dealing with all the various issues that were pertinent to women. And then we've had a long-standing fiscal and economic group that gives us a great review of the U.S. Economics and the state of Illinois each month. We have an election outreach where we're working with federal, state, and local folks, a climate change group that is doing a lot of work on the IRA. That's the Inflation Reduction Act, which is really about climate, get rid of carbon, going green. And then tonight, we're going to have Rod, Ed Spire, who is one of the co-leads of Rod, present. And Rod covers a whole variety of things, from voting rights to elections to gerrymandering, vote by mail, and covers very specific issues that come up. They also have another group which has been working with confronting disinformation. So those are our issue groups. And tonight, Ed Spire will be talking about the 14th Amendment. And as you can see, it's getting a lot of interest. We're still having people join. On the left-hand side is all of our communication team. It's what we do to get information out. And many people that say, my God, if I get one more email, one more text, one more tweet from you guys, I'll go crazy. But then the next week they say, I didn't see anything from you guys, so let me know. So we over-communicate. I apologize if anybody feels like we've over-communicated to you, but our goal is to get the information out. That, I'd like to turn it back over to Ed.
Bill likes to use the term ROD as if everybody understands what that means. ROD stands for Restore Our Democracy. This is a project that Jim McGrath and I have been running here at NWSOFA for a few years. And we're all about how our democracy works. So let me start by sharing my screen, and we'll get into this presentation tonight. All right, very good. So we're going to talk about Section 3 of the 14th Amendment and how it applies today. We're going to talk about an overview, what exactly does the third section say, why it was created. We're going to talk about whether it applies now, why and how states are applying it. We're going to talk about the way people have tried to put off a decision along these lines with various defenses, as you see here. We'll see the legal opinions that have been rendered, some of which were just rendered today. We're going to talk about how the Supreme Court will respond to this, what it means to us, and what we should do about it. So this amendment was created after the Civil War. It's created by primarily the Congress of the northern states, because the southern states were kind of not represented in Congress during and after the rebellion. So the 14th Amendment is the response of the federal Congress to the Civil War. And it granted citizenship to all persons, so that we didn't have a bunch of slaves who couldn't vote. It authorized the government to punish states that would not provide voting rights as they should. If you, as a state, would not provide voting rights to your population, you were going to be penalized in your representation in the House. It prohibited former Confederate states from repaying war debts and compensating former slave owners. It granted Congress the power to enforce the amendment through legislation, and it required Confederate states to ratify this amendment if they wanted to return to the Union. So it was a strong response to the rebellion that was the Civil War. And the Section 5 of the 14th Amendment, the 14th Amendment has 5 sections. First one is basically everybody here gets to vote. All persons born or naturalized can vote. Section 2 talks about how representatives will be apportioned, but if any state refuses to grant the right to vote, that their representation in the House is going to be diminished. And that gives every state the incentive to actually allow their citizens to vote. Section 3 is the one we're going to discuss in detail going forward. Section 4 has to do with how states repay their war debts. And Section 5 simply says that Congress will have the power to enforce this amendment through legislation. This was approved in 1866. In 1868, it was declared certified by all the states. Most of the southern states refused to ratify, but there were enough states that ratified it that it became law. But then there was a Reconstruction Act in 1867, which sets the conditions that they had to accept it before they could be remitted. So eventually, all the southern states did ratify this because that was the only way they could rejoin the Federation. We want to focus on 14.3 here, the third section. And it's pretty clear. No person who, having previously taken an oath to support the Constitution and then shall have engaged in insurrection or rebellion or given aid and comfort to those who did, shall not be allowed to be elected to positions of responsibility in the federal government. That's the essence of what this amendment says. And Congress can remove that disability. This is a qualification for office. It's very similar to the qualifications we have elsewhere in office. Like the Constitution says, in order to be president, you have to be 35 years old. You have to be born in the U.S. Those are qualifications for office. This is another qualification for office, which even though it was added through an amendment, it still has the same force of all those qualifications. And only if 2/3 of each house of the Congress will vote to suspend this for any particular candidate, can a candidate then be qualified to hold office in federal office. Why was this created? Well, this was created because the Congress was worried about the people who had fomented this revolution in the South regaining political power. They wanted to prevent former Confederates from holding public office. They wanted to promote loyalty and stability to the federal government. And they wanted to ensure that the Reconstruction that was initiated by the 14th Amendment would go forward, that in fact, we would stop people from violating people's civil rights by disallowing them to vote. This clause was intended to propose a role in Reconstruction by ensuring that Reconstruction would go forward and that the people that had insisted on slavery as a way of life would not be able to gain power and stop the Reconstruction process that the northern states were bringing forth on the nation. So that's why this part of this amendment was created. Now, yes, Congress can remove the disability by one slide too many. Congress can remove the disability imposed by this amendment by 2/3 of a vote of each house of Congress. And you know what? Congress eventually did succumb to political pressure to not only pardon the rebels, but to remove this prohibition against their holding office. And let's take an example. Let's learn from what happened when Congress pardoned these people and allowed them to return to political life. The result of allowing these rebels to return to political life is that they regained political power and they stopped Reconstruction. They found a way to finagle things so that Reconstruction was delayed and stopped, and they were able to implement the Jim Crow laws in the southern states that impacted the rights of of African American citizens for decades. The people who wrote this amendment wanted it to protect our country, but in the final analysis, political considerations allowed Congress to overturn that and to allow these folks back into power where they did things that weren't really in the best interests of our nation. So I take that as a lesson myself. Let's not do that again. Let's not just shine this on and say, "Oh, give them another chance." We gave them another chance. They did really bad things for the nation. We shouldn't give them another chance again. In my view, Constitution. So it's powerful not just for today, but for all days going forward, because this could happen again. And we want to make sure that we have a defense against it for the future. And that was wise. That's why it's not just a law, it's an amendment that applies today, because they knew it could happen again, as it is happening again now. So how does this apply today? The question is, was there an insurrection? Well, you can look at what that word means. And we've got several definitions up there: violent uprising against authority, an act or instance of revolting against civil authority, an organized attempt to defeat the government, take control of the country, usually by violence. What were the goals of what happened on January 6th? Was that an insurrection? They were determined to stop the counting of the electoral ballots. They wanted to make sure that fake electoral ballots were counted. They wanted to hang the guy running the process. They wanted to prevent the peaceful transfer of power. They wanted to keep Trump in office. And the bottom line is they sought to use violent force to get their way, to keep Trump in power by preventing the joint session of Congress from counting the electoral votes and formalizing the election of President Biden. There were hundreds arrested, prosecuted, and convicted. All of that shows that our legal system sees this as an insurrection against the normal way our government is supposed to run. So if there's any question about whether this is an insurrection or not, I think the evidence is clear. And in fact, several courts have looked at the evidence and determined that the evidence is clear. All these things taken together are considered as a single act or instance of revolting against civil authority or of an established government. So several courts have looked at this and said, yeah, this is an insurrection. And Trump was involved. How did this go down in Colorado? Well, first of all, let me say that my understanding of how elections are run is that states run elections, and state officials who run elections all take an oath to support the U.S. Constitution. You know, I'm an election judge. Even at my level, I have to swear an oath to support the U.S. Constitution before I can participate in running an election in a polling place. Certainly, the Secretary of State or everybody involved in running an election in a state takes an oath to support the U.S. Constitution. Well, some people in Colorado thought that their election officials were not supporting the Constitution because they were allowing Trump on the ballot, and they believed that Trump should not be on the ballot because he supported an insurrection. So they filed suit. They filed suit in Colorado. It was a civil suit claiming that the Constitution means that Trump can't be on the ballot. And, you know, that's exactly how this kind of thing is supposed to work. States run elections. States should decide who can be on the ballot or not. If some state makes a decision that some people don't think is right, they bring suit in state court to try and correct that. So as a civil suit, it was a bench trial. And the judge at the bench trial looked at the evidence, listened to the attorneys from both sides, and decided, yes, he did support an insurrection. Now, the judge at the bench trial level said, I'm not so sure that applies to the president. So the bench decision was, yes, he participated in an election in a insurrection, but they don't think the law applies to the president. So then it got appealed to the Supreme Court in Colorado, and the Supreme Court said, of course it applies to the presidency. All you got to do is look at the Senate debate when this amendment was passed. The Senate debate when the amendment was passed clearly says, of course, it applies to the presidency. So Supreme Court upheld the finding of fact that Trump did participate and support in an insurrection, and that 14.3 applies to him, and that he can't be on the ballot. Now, of course, they said, we know this is going to be challenged. We know the judicial system is going to have the last word. The Supreme Court's going to have the last word. So we'll stay our decision until the Supreme Court rules on this. But to say that this was, a lot of people say this is just Democrats piling on Trump. Well, that's nonsense. The people who brought that suit in Colorado were Republican voters who don't want Trump to be their candidate. And the deciding vote in the Supreme Court was cast by a Republican judge. So this is not just Democrats doing this. In Colorado, there was a lot of support amongst Republicans to consider this process. So Maine had a little different approach. In Maine, and this is something that I personally respect, in Maine, the top election official said, I swore an oath to support the U.S. Constitution. And the U.S. Constitution says, basically, that Trump can't be on the ballot. So I decide he can't be on the ballot. Now, I know this is going to be challenged in court. It's going to be a compressed time frame. The top official says, I'm going to suspend the action here based on court review. But I'm pretty clear that my decision is right. So Maine took a little different approach. In Maine, the people who run the elections, I believe they honored their oath to our Constitution and chose what they think is the right path based on their understanding of what Trump had done or not. But it still ends up in the courts. It still ends up at the Supreme Court, and the Supreme Court is going to make the decision here. So that's the difference between Maine and Colorado. And I'll say this is being discussed here in Illinois right now. And right now we see Illinois doesn't give the Secretary of State the power to run elections. They give it to the Illinois State Board of Elections, which is a bipartisan group. And it's doubtful that a bipartisan group is going to rule that Trump shouldn't be on the ballot. But I don't think it matters. I mean, at this point, it's in the hands of the Supreme Court. The Supreme Court's going to decide for the nation whether he's on the ballot or not. And that's going to apply to all states. So it's interesting that it's being discussed in other states, but I don't personally think it's a big deal. Now, if you look at what other judges have said, it's interesting that one of the current judges on the Supreme Court has said in the past that a state does have a legitimate interest in deciding who should be on the ballot. States are constitutionally charged with running elections. So, of course, states are the first line of defense of making sure that people who are constitutionally prohibited don't appear on our ballot. And that was even in a Colorado case prior to when he joined the Supreme Court. So there's a precedent there that says, yeah, a state like Colorado can, in fact, say you're not qualified. In this case, it was somebody who was underage. But if you're not qualified because you've supported an insurrection, you're still not qualified. So that's an interesting precedent here that's going to weigh heavily on the Supreme Court when they judge this. So let's talk about the various defenses that the folks who want to see Trump run will raise. They've talked about maybe it doesn't apply to the president, maybe there wasn't due process, he wasn't convicted, there needs to be enabling legislation. Let's talk about each of those. Does it apply to the president? Well, all you have to do is look at the historical record. The Senate debated this stuff, and I have to say I'm very proud of the Senate deciding to put this in the Constitution. They debated this thoroughly, saying this was an attack on our republic. And one of the guys in the Senate basically said, I don't see the president specifically mentioned here. Why did you exclude him? That was Maryland Democratic Senator Reverend D. Johnson. And one of the other senators, Morrow, came back and said, let's make it clear to the words, hold any office, civil or military, under the United States, saying that includes the president. It's very clear from the historical record of Congress that it does apply to the president. It was debated openly and stated clearly in Congress that it applies to the president. Let's talk about lack of due process. Well, there was a court proceeding in Colorado, and that court proceeding did have due process. Both sides were represented by counsel, both in the bench trial and the Supreme Court hearing. Both sides made their cases. Evidence was produced. The bench judge made a decision. That's what judges do. They judge. And the judge decided He did he was involved in a revolution, in an insurrection, and the judge was unclear whether this applied to him or not. The same kind of due process occurred in the Supreme Court in Colorado. The lower court's finding of fact, both sides were represented, both sides got to make their arguments. The Supreme Court decided that the lower court's finding of fact that Trump had engaged in the insurrection was not overturned. Colorado, the Supreme Court, believes that Trump did engage in an insurrection. And, it's rare for an appeals court to overturn a finding of fact. Appeals usually hinge on point of law, not finding of fact. But the point of law that the Supreme Court disagreed with was that, in fact, this law, 14.3 in the Constitution, does apply to the president. So the result of the appeal to the Supreme Court was not to damage the case. The result was to confirm the case that Trump may not be on the ballot in Colorado. And once again, of course, the Colorado court understood that the Supreme Court will have the last word, so they stayed any action based on what the Supreme Court's going to do. But there was full due process in the Colorado court system. Well, some people say, well, Trump hasn't been convicted of insurrection. But once again, you have to look at the situation when this amendment was passed. When this amendment was passed, there was no federal law about insurrection. There was no law he could have been convicted under. Not only that, the Southern rebels had been pardoned by President Johnson. So even if there was a law, these people couldn't be convicted. And yet the Congress passed this amendment. The amendment doesn't call for conviction. The amendment just says, if you participated, you can't hold federal office. And the reason they didn't call for conviction is because they knew that conviction was impossible. No law, and they'd been pardoned. So the constitutional amendment doesn't require a conviction. And the Colorado judiciary agrees with that. They determined that he did engage in insurrection, and they determined that was sufficient to apply the 14th Amendment, Section 3, to bar him from being on their ballot. They're saying that the 14th Amendment, Section 3, requires some kind of enabling legislation. And that kind of ties back to what is in 14.5. The fifth section of 14 says, Congress shall have the power to enforce by legislation the provisions. Well, that's obvious. Of course, the Congress can pass laws to enforce our Constitution. What 14.5 is really signaling is that the framers of the amendment wanted Congress to pass such laws. And, they did pass a bunch of laws, but they're mostly focused on areas of the 14th Amendment that weren't 14.3. They may have even passed some legislation regarding 14.3, but I don't see it on the books anymore. I don't see it being there anywhere. That's not the point. The point is, do we need enabling legislation in this area? Let's talk about why you would or would not have enabling legislation for some part of our Constitution. When we have laws on the books, the administration can move to enforce them. Somebody breaks a federal law on the books, Department of Justice can go after them, bring a criminal indictment. Enabling laws for our Constitution allow our government to take direct action to enforce our Constitution. But what happens if there is no enabling law? If there's no enabling law, then actions which violate our Constitution, but not any law, they can still be enforced. They're enforced by criminal indictment. They're enforced by civil suit, like the civil suits that were brought forth in Colorado. Specifically, if you're damaged by somebody who acts unconstitutionally, you can bring a civil suit, which is exactly what happened in Colorado. Any elected or appointed official in federal or state government swears this oath to support the Constitution. It's their responsibility to act in office in a manner consistent with the words and meaning of our Constitution, whether or not there is enabling legislation. If someone has sworn such an oath, they act in a manner that is not consistent with our Constitution, then anybody else can file a lawsuit, which is exactly what happened in Colorado. So you don't need, enabling legislation is good if you have it, but you don't need it to enforce our Constitution. Let's put all that into the context of how our states run elections. Everybody involved in running an election, from the Secretary of State right down to me working in a polling station, swears an oath. Here's the oath that I have to swear before I can help run an election in a precinct or in an early voting site. I will support the laws and Constitution of the United States. I will faithfully, honestly discharge the duties That right there says that everybody involved in elections is supposed to pay attention to what the Constitution says about how we run our elections, about who can be on a ballot. Now, certainly, me as an election judge is not going to say Trump can't be on the ballot, but the Secretary of State or the Illinois State Board of Elections or the fellow in Maine that decided this, they have every responsibility of implementing our Constitution. Our Constitution calls for states to run elections. Our state officials are responsible for ensuring our Constitution is upheld. Everybody who works on a Constitution is responsible for ensuring that our Constitution is upheld. And it doesn't matter whether it's a presence or absence of federal legislation. That makes no difference. Certainly in the absence of naval legislation, DOJ can't enforce this clause, but all of us have to do it. And anybody who thinks we're not doing it can bring a suit like they did in Colorado to make us do it. And that's what happened in Colorado. So that's how this applies to our elections today. There's a lot of opinions. These guys at U of C, at University of St. Thomas in St. Paul, Minnesota, they wrote a paper arguing the selection to be enforced by every official who determines qualification for office. And Section 3 remains an enforceable part of the Constitution, is not limited to the Civil War. They said clearly, we want this in our Constitution so it's important going forward, not just now. And the bottom line of all of that is that Trump engaged in insurrection. It gave him comfort. And the authors of this position was backed up by Michael Ludwig, a former conservative judge, the U.S. Court of Appeals, and Lawrence Tribe, a liberal law professor. People on both sides of the aisle are saying that this law is clear. And in fact, the House committee investigated the events of January 6th and recommended that Trump be barred from holding office. And so it's not just these legal people, it's also the Congress of the United States. There are other people who have other ideas. There's a guy at Northwestern, Stephen Calabrese, who reversed his position. He was won over by a Wall Street Journal opinion piece, and the issue there was whether the amendment affects someone who had already been president. And some other legal people who looked at that and says, well, it's pretty clear that the scope is limited to the people who, as a member of Congress or as an officer in the United States, have taken an oath to support the Constitution. And, well, yeah, is Trump an officer of the United States? Somebody says, well, that only refers to appointed officials, not elected ones. Some of the people said, let's be clear, that's a genuinely stupid argument. Clearly, the president is an officer of the United States. So there's opinions on both sides. There's lawsuits pending on both sides. Several states are considering. I just mentioned that Illinois is certainly considering. I don't think it matters. SCOTUS will decide. The Supreme Court will decide. Here in Illinois, it's being taken up by the State Board of Elections. They don't want to rule on this because they're bipartisan. There's 4 Democrats and 4 Republicans. Why would they take a side? So I'm not sure what's going to happen in Illinois. It might go through the courts. But again, I don't think it matters. What really matters is how the Supreme Court will respond. There's 2 possibilities. I mean, they could decide that Trump can't be on the ballot. I think that's extremely unlikely. The Supreme Court is extremely right-wing biased. I think they're going to let him run. So I think they're going to have to find that one of those various excuses that most legal scholars think are untrue will take precedent. It doesn't apply to the president. It requires enabling legislation. It doesn't have due process. It requires a conviction. So I personally think they're going to seek a resolution that doesn't set a firm precedent, maybe requires a conviction or some other obscure point of law. But there's still a lot going on about this because this is a major problem for the Supreme Court. This, what I'm showing you, these next 2 slides just came to my attention yesterday. 25 historians, 25 preeminent Civil War and Reconstruction historians, amongst them James McPherson of Princeton, the preeminent Civil War scholar, have just filed an amicus brief with the Supreme Court in support of Colorado that Trump should not be on the ballot. For historians, the contemporary evidence from the decision makers who sponsored, backed, and voted for the 14th Amendment is what counts. And what they said is that they crafted Section 3 to cover the president and to create an enduring check on insurrection, requiring no additional action from Congress. For these guys, clearly, they said it's clear. It's just crystal clear to them. And the problem is that the Supreme Court justices who subscribe to originalism, that attempts to divine what the founders and the framers meant, this is going to fly in their face. Because while they have used originalism to reduce reproductive rights, to voting rights, to gun rights, when they're faced with this, originalism says Trump can't be on the ballot. That's what the intent of the people who drafted this part of our Constitution clearly says. And the Supreme Court has reached a point of no return. The law, no matter the diversions and claptraps of the lawyers and pundits, is crystal clear on the incontestable historical as well as originalist grounds. And conservatives face a choice between disqualifying Trump or just shredding the foundation of their judicial methodology. And that's from Sean Wilson in Princeton, who is another eminent historian who wasn't part of the brief we just talked about. So this is a really major problem for the Supreme Court. They really do not want to rule that Trump can't be on the ballot, because that's just going to really, really piss off everybody that put them in power. But the law kind of says they have to do it. So what does it mean for us? Well, if the Supreme Court really is going to not do the right thing and keep him off the ballot, it means we have to defeat him at the ballot box. So we knew that, and we're all working to do that. But it also means that the reputation of the Supreme Court will take a huge hit. And so what we need to do as citizens who understand all this stuff, we have to, first of all, debunk the idea that Democrats are trying to kick Trump off the ballot, because it's not Democrats. It's Republicans who don't want them to be his candidate. We certainly have to defeat him at the ballot box. And we have to ensure that everybody understands that if SCOTUS does what I fear they're going to do, that SCOTUS has just completely abrogated their responsibility for supporting our Constitution and our democracy. So that's what I've got to say. We have 20 minutes left. I'm going to send these slides out. Here's all the references that I've used in building this presentation. We're going to send these slides out. You'll have all these links. You can research this stuff to your heart's content. And I'm open to discussion on this. You know who I am. There's my email address. You want to talk about this further? I'm ready. And we're going to open this up to questions now.